Hello, this is Kid Malek from Malek and Malek. Today in this video, I'm going to talk about how to raise your comp rate or how to raise your wage rate. Why would you want to do that? So, when you file a claim, the BWC will reach out to you and they'll want to get all your wage records, W-2 information in the year leading up to the date of injury. So the 52 weeks prior to your date of injury, they'll want all the wages that you've earned during that time. So if you got injured on, say, July 5th, 2020, they'd want all your wage records from July 5th, 2019 up to July 4th, 2020. And the typical wage calculation is such that they're going to take all those wages, divide it by the number of weeks in a year. So the number of weeks in a year are 52. So they're going to take all your wages divided by 52. That's going to be your wage rate. And what's going to happen is that'll be your AWW. So what they're going to do if you apply for comp, temporary total disability comp, they're going to take the standard formula of 6 and 2/3 times that wage rate, the AWW rate, the average weekly wage rate, and then that's what you're going to get each week for your temporary total disability comp. So for your purposes, in order to maximize the amount of comp you're going to get each week, you're going to want to get that number up as high as possible. Otherwise, you're not going to the money you're going to get is probably not going to be even touching to what you're making when you're working. And one thing to realize is when you're on comp, temporary total disability comp, remember it's going to be 6 and 2/3 times that number. So it's not 100% times your basically what you'd make each week. It's going to be 6 and 2/3. So you're already taking a hit. So that's why you want it to be as high as possible. One saving grace is temporary total disability comp is not taxable income, so you're not going to file taxes on that at the end of the year. So if you're off work for a year, for the year of 2020, you're off the entire year, you're not going to pay taxes on any of that income. So problem arises when that standard way that the BWC calculates your wage rate isn't sufficient to adequately represent your weekly wages. Otherwise, if they did that add all your wages divided by 52, you might end up having a really low wage rate. And how would that happen? Let's say you were unemployed for a certain number of months of the year, or the year leading up to your injury. It's not uncommon for people to start be unemployed for a while, and then they start back up. They work for a month or two, and then they get an injury, and then so if you work 2 months, that's going to be only 8 weeks of wages. So you wouldn't want to. And if you didn't work those other weeks in the year leading up to the date of injury, then you're going to have 8 weeks of wages divided by 52 rather than 8 weeks of wages divided by 8. So that's the most common way to raise your wage rate is to exclude weeks of unemployment. So that's one of the most common ways to do it. If your wage rate is really low, see if there's any weeks that you didn't work. Try to get those excluded. But that's not the only way. And so within the Ohio Revised Code, section 412361, they have this thing where they say, and I'll just read it. Special cases, special circumstances. In cases where there are special circumstances under which the average weekly wage cannot be justly be determined by applying the section. So that's these paragraphs above, which I'm not going to read. But the administrator of the workers' compensation in determining the average weekly wage in such cases shall use such method as will enable the administrator to do substantial justice to the claimants. So in special circumstances, the administrator, i.e. the BWC, can deviate from the standard, divided by 52 and craft other ways in order to raise your wage rate. Now, if you're going to try to find a alternative like formula or solution to get your wage rate, it's probably not going to happen at the BWC, because when the BWC, it's a bunch of they're not attorneys. Well, there's attorneys that work for the BWC, but the folks that are going to be messing with your claim reps, they're not attorneys. They're kind of limited on what they can and cannot do. So if there's any kind of question about, like, let's say you submit a motion to have your wages raised, and it's just wishy-washy, they're not really feeling it, they're going to bounce it. They're going to say, hey, we're not going to raise it, and then you could appeal this order, and then they're going to bounce to the Industrial Commission, and then your attorney is going to have to argue, hey, you need to do, this is why this calculation should be followed. The employer or the BWC's attorney is going to say, this is why it shouldn't be, and then the hearing officer is going to make a determination of what to set the wage rate at. So, anyways, how does the special circumstances work, or how has it worked? I'm going to go through two cases, and then they kind of show their circumstances where these cases went up to the Supreme Court. So, and the Supreme Court looked at the background of these injured workers, and they basically said, yeah, going with the standard formula isn't going to work. It's not fair, so we're going to propose something different. So the first case I'm going to go over is this. It's called Clark versus Industrial Commission. And then so this individual, this lady, she had gotten injured. The BWC had set her AWW to 1349. So, which is terrible. Which is, I mean, what's the point, frankly? So what they ended up doing is she had worked, I don't know, she had, I think, 4 weeks of wages, and somehow she wasn't really working that much even in these 4 weeks. But she had wages in that time, for whatever reason, of $53.94. These were the wages that were reported. So they did, I think what they ended up doing is they took these wages and divided by whatever it was, they divided by 52. So her AWW, whatever the wages were, they divided by 52. So instead of, and she had the issue in her situation is she had been unemployed for all this time, and she had just started this new gig. She'd worked for 4 weeks. She got injured. The BWC excluded the weeks of unemployment, but they still somehow got her AWW to 1349. So if you do that 6/6 and 2/3 of 1349, you know, her temporary total disability rate would be $8.98. So I mean, that's kind of pointless at that rate. So, So what the court says, they sent it back to the IC and basically said the injured worker had submitted an affidavit that stated prior to the injury she was working roughly 37 hours, 0.5 hours a week, and therefore that the wages she would have been making going forward. So if she worked 37 hours and 37.5 hours a week, the wages that she would make during that time is what the wage rate should have been set at. That would have been a fair result, and that's what the special circumstances are supposed to do. It's supposed to give you a fair result, and what they say is substantial justice without giving the injured worker a windfall. So they want to be fair, but they don't want to give the injured worker a bonus for being off work. Because the one of the driving things of temporary total disability in the BWC is the intention is not to keep people off work, is to supplement, help people stay above water, and so that they can go back to work, heal, and go back to work. So that's what the court ended up doing that way. So, and this could be one of those things that might be relevant in your situation. If your wage rate's really, really terrible, you could say, hey, I would have been making this amount of money going forward each week. You probably have to substantiate that, again, with an affidavit. You're going to have to go to a hearing. You're going to have to explain, and it's going to come down to whether the hearing officer, how reasonable and fair they are, I guess, and then how compelling and how you come across. So that's one situation. So basically the court is like, they threw out the typical way to calculate it, and they just said, okay, what was she going to make going forward? That'll be her weekly wage rate. And they also substantiated that by some of the wages that she would have made that she made in the weeks before the injury. So the second situation, the second case I'm going to talk about, it's called Smith versus IC. There's another House Supreme Court case. And the way these things work is when you submit a motion, you're going to submit a motion at the BWC C86 motion saying, hey, raise my wage rate up to this for this reason. Here's the evidence supporting why it should go at this point. BWC is going to review that. Again, like I said, if it's too clever by half, then the BWC is going to say, hey, no, and we're going to deny that. They'll issue an order denying it. You appeal. It's going to go to the IC. You'll go through your typical DHO, SHO, and then if you lose at the SHO, then what happens is you're going to file, your attorney is going to file they're not going to file a 512 appeal, but they're going to file what's called a mandamus action, and that's going to go to the Court of Appeals. Depending on how that goes, then that's either going to get, remanded back, or you could appeal to the Supreme Court. They may or may not take it. So that's how these cases got up to the Supreme Court. So this guy, he had just started working at a drill site. Looks like in the year prior to the date of injury, he was unemployed for a number of weeks. And the other significant thing was that he was working, he operated a gas station at a loss. So while he's working or operating the gas station at a loss, he's not technically unemployed. So typically, he's working, so they would have counted those weeks. And so by counting the weeks where he worked at the gas station at a loss, I mean, if you're making a loss, you're making negative money. So for the purposes of the wages you made during that year, it's a zero sum. So if you're unemployed, you get zero, and you exclude those weeks. But if you're working and you're not making any money, typically you would make zero, but you would include the weeks if you would follow the typical way the BWC does things. So what happened is, the BWC took his wages, exclude the 20. He was unemployed for 22 weeks, and so that was the denominator was 52 minus 22 is 30 weeks. So instead of dividing his wages by 52, they're dividing by 30, which you would think would be good, but in this guy's case, his AWW was still pretty terrible. So his AWW is 162.58, and what would happen is, 6 2/3 of that, you get 108.39. So that's how much he'd get each week, for each week he's off of work. And if you're off work for a year or a year and a half, and you're only making $108.39, I mean, that's terrible. I mean, you can't survive off that. So the court, this went all the way up to the Supreme Court, and the court said special circumstances existed in this situation. The court said it didn't make sense to include the weeks that he wasn't, he was operating at a loss, so where he was making $0. So they basically treated those weeks as unemployed weeks as well. So instead of dividing all his wages by 32 or 30 rather, they also removed the 21 weeks where he was operating at a loss. So they excluded, it looks like, 43 weeks, I think, and then so they only included 9 weeks of wages. So that was the math calculation, was whatever his wages were divided by 9, which is, you're going to get a better result. A smaller denominator, you're going to have a bigger product or bigger, number when you do the math. So he had $4,877 divided by 9. He got 541.92. Much better than 162.58. So I would much rather prefer getting my AWW being 541 versus 162. So that's how the court treated special circumstances in these two cases. There's a lot of other cases, and in this whole area of law, it's a lot of room for movement. So I'll probably go over some other cases, other situations in future videos. But the easiest thing to do to raise your wage rate is exclude the weeks for unemployment. So I'm going to talk about an example of how the IC. This is a like a recent issue that I ran into at the IC. So I had an individual who was basically he was a tipped employee. So his wages that he was making were like below minimum wage. And if you work in an industry like restaurant industry and bar industry, they'll either pay you like a very de minimis amount, and then the idea is you're going to make your money up in tips. So in this case, that's what he did. The employer paid him whatever sub minimum wages that he was paying, and then what he did is that's what he was taxed on. That's what this guy paid taxes on, and that's what the employer, he paid his workers' comp premium and everything else based off of this de minimis amount that this guy was being paid. So the problem is this guy would make like a very small amount in wages, and then he would make substantially more in tips. So what we want to do is have his wage rate reflect both his wages that were taxed and his tip wages. What this individual chose to do, and neither here nor there, but he got his tips, and he's like, okay, these are my tips, and I'm not going to pay taxes on them. And so what the IC did, and I think they overreached. I think their decision was arbitrary. I think they're trying to play a role that they're not supposed to be playing. But they're basically saying, hey, this guy didn't file an amended tax return. He didn't pay taxes or file taxes on those wages. Therefore, I don't find his affidavit indicating the tips that he received as credible. So we're only going to include his taxed wages, or the wages that he paid taxes for, or that were reflected in his W-2 as part of the wages that we're going to use in the wage calculation. So in that instance, the hearing officer is basically, like I said, overreaching. That's not the hearing officer's responsibility to ensure that somebody is or is not paying taxes, or is not following this or that rule. So he got it wrong. He denied the wage rate increase, but I do think he got it wrong. But my point in this is, for those folks who are either tipped employees and they don't pay a lot of taxes because they're just not paying taxes on their tips because probably don't make that much money anyways, and it's one thing when you're making 20 or 30, like paying just a little bit is a huge impact versus some hearing officer or attorney or doctor where we're making however much money, and if we have to pay taxes, it's like it's just not a huge proportion of our income. It's fixed in how we do things. It does have an impact, and I know these hearing officers. I think the hearing officer, I looked it up because it kind of pissed me off. But I think that hearing officer, you could look up all these guys' salaries, but I think he made like 110 or $120. Good money if you get that job. $120 to sit there and listen to people's hearings all day. But so for him, paying taxes, probably not a big deal. But if you're a dude or a woman making 20 or 30K a year, and if you have kids and you pay rent and you pay a car bill and you pay whatever medical that you have to pay for, and every other thing that you have to pay for, every freaking penny counts. And that's why you got to get these wage rates raised. But my point on this whole thing with the taxes is, the BWC, I think it's a policy, either unofficial or official, that's become more and more of a thing in recent years, is they're dinging people if you don't pay taxes on income. So if you're either a tipped employee or you're somebody who works under the table, you're a housekeeper that works under the table. And what I mean by under the table is you work with cash and you don't pay taxes. A lot of employees or laborers who work on roofs and these sorts of things, landscapers, they're paid, maybe a daily rate or a weekly rate, and they're paid in cash, and they probably don't report those to, the IRS or whatever. I guess you should, but, that's neither here nor there. But the point is, the BWC is dinging those people. So my suggestion is you should probably pay taxes, not only because you know that's the rule in the United States, you got to pay your taxes, but also if you were to get injured, you might get dinged. So you benefit most of the time if you're not injured by not paying taxes, but then when you in not reporting it, but then, and I think that's why the BWC and this hearing officer, you know, one instance you're benefiting from not paying taxes, and then the next instance you're getting hurt or whatever, and then you're saying, oh, include these wages that I didn't pay any taxes on. I think that's where they come down, and that's why they're not too. They like to, they you know they like to use it against you, or you can't benefit in one instance and benefit on the other hand in another instance. You either got to choose. So if you benefit there, you're going to lose there. If you lose here, you're going to benefit there. But it doesn't just go against injured workers. Another instance, a good example is employers. So going back to roofers, all those most folks, if they're doing roofing, a lot of these people that are doing roofs, when you go around your neighborhoods and you see people doing roofs, that employer is probably going to say, oh, all these people working on this roof, they're independent contractors. So that person's not paying payroll taxes, they're not paying any kind of workers' comp premium on the wages that they're paying out. They don't have any workers' comp coverage for these folks. So they're that employer who claims he's not an employer, but that employer is benefiting by not classifying or doing the due diligence to you know, dot the I's and cross the T's by doing all these things that they're supposed to do. And what happens is, as gravity is a thing, folks fall off these roofs or get injured in a myriad number of ways, and then they file a claim. Employers claiming or makes the argument, oh, this guy's an independent contractor. The Industrial Commission, the BWC, they're like, no, they've got these indicia of being an employee. We're going to treat that guy as an employee. You're going to have to negotiate to get coverage. And, you know, so I get that that employer benefited at the one instance, but we're not going to let them benefit when the injured worker gets hurt. So you either take a loss or take a cut and pay, you know, do things right, get coverage for your roofers, and then you got the protection when that person gets hurt, or you don't, and then what you're going to have to do is you're going to have to negotiate coverage, and the BWC might not let you do that, or you're going to have to roll the dice and see if you get this claimant be classified as an independent contractor. So, irregardless, there are many other ways to raise your wage rate, but you do want to get that as high as possible. Again, the easiest way to do that is exclude weeks of unemployment. If your wage rate is low, you can again file that motion, have it raised. Once you file that motion, you want to have all your cards and everything, all your ducks in a row. Because you're not going to be able to, if it's raised, you're not going to be able, they're not going to give you another bite at the apple at the Industrial Commission to you find some other piece of wage information to try to raise it again. So it's kind of a one shot thing. So get all your ducks in a row, and then the way it works is if you could go back 2 years from the date of filing of that motion. So let's say you got injured in 2018, your wage rate was terrible, and you, for whatever reason, you didn't pay attention, or there was other things going on, or you weren't represented, you didn't know you could raise your wage rate. Then, you know, if it's 2018, if before that anniversary of in 2020, you could file that motion, and you could go back if you receive comp during any period of that time. That the comp will be paid at that higher rate. So if you, just for simplicity's sake, because I'm not a math magician, let's say you're receiving $2 and a week or whatever, and then their wage rate was raised to $10 a week. So all the comp that had been paid at $2, you're going to do 10 minus 2, you get $8. So you're going to get the difference. So you're going to get the $8, and you get that accrued comp, you'll get it one lump sum, and then going forward, you'll receive comp at that higher rate. And then the other thing that's significant is that higher rate will figure into your permanent partial disability award. So It's important that you raise it. As I always say in all these videos, if you have any questions about anything, it's absolutely makes sense for you to reach out to a workers' comp attorney. Malek is a great workers' comp firm. We've been doing this for a while. We have a lot of experience in all the aspects of workers' comp law. We deal with easy cases and we deal with hard cases. But if you don't come to us, at least talk to somebody, talk to a workers' comp attorney. There's a lot of good workers' comp law firms in Ohio. If you go to one of our competitors and you get a good result, I'm happy for you. That's great. I just don't want to see injured workers getting screwed over because they don't know how to do something or they get bamboozled by the law. So if you want to talk to us, it's free. We'll give you a consultation. We'll let you know, hey, this is the difficulty with your case. This is the ease of your case. This is the problems you're going to run into. We'll let you know, hey, maybe you don't need an attorney, or hey, we do think you need an attorney, and this is what you're going to have to do forward in your case to get the result you want. So I will be, if you talk to me, I'm going to be 100% honest as to how your claim is going to go forward and what we're going to need to do. Irregardless, thanks for watching this video. If you have questions, concerns, comments, you can either leave them in the comments or you can email me, or you could call the office, and then I could see if I could answer your question to the extent that I'm allowed to answer it. Otherwise, please stay safe and no injuries, and have a nice day. Thank you.